Come up, Mr. Jones.
Mr. Nayland is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
so
understand.
I'm kind of filling in. I have.
This is where the tone of the hearing quietly shifts. 19 missed blows isn't just a number. In probation terms, it's a pattern. Breath testing is treated like a zero-tolerance contract with the court. Misses are often viewed the same as refusals because the system assumes accountability is non-negotiable. Question for you watching. Should missed tests always be treated like failed tests, or does context matter?
I had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
That's 19, Your Honor. That's 7. Within that 7 are included. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Justin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzer?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer.
Listen closely to the desperation here. This is the moment defendants usually realize the court has emotionally checked out. Offering alternatives, drug programs, monitoring, promises, sounds reasonable, but legally it's often too late once a judge decides credibility is gone. From a courtroom perspective, this isn't about substance use anymore, it's about trust. Do you think the judge had already made up their mind by this point?
The utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please.
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate. For alcohol.
I go to sleep early, man.
Test. And he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I have a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I'll do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond for it?
Of course.
Oh my gosh. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that like, there's.
It's the same thing. If we can't see you in the camera,
Yes, sir.
then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, respond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because, fine. Mr. Thurman, you're back. Okay. So I told you before, two main concerns are, number one, are you going to go back to the jurisdiction where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime, there's such a thing as lifetime probation?
There is.
Yes.
Whoa.
So that case, well, I'll let you do the talking.
No, he did his time and he got out and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how what would, aside from like a murder case,
So he was
what
charged
would
with
garner?
murder twice, along with 2 armed robberies.
I wasn't charged twice with no murder.
It just shows up.
It just shows up
Oh, I
twice.
was about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been
This is where things escalate fast. Lifetime probation, interstate supervision, and an armed robbery background immediately trigger public safety red flags for any judge. Once interstate compact issues come into play, bond decisions become far more rigid. Sometimes the judge's hands really are tied. And when children are mentioned as witnesses, that's a nuclear button in bond hearings. Should prior history outweigh present-day compliance? Let me know what you think.
charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, even threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA. But I don't have the documents, which is why I can't present them. If there's an ICA hold, he is ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say. But if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor?
Of course.
Okay. After we talk about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information and why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though. So
I understand.
That's why he overlooked. He said, okay, it's fine. So he said it was fine.
Quick question, is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've
It's
not
this month.
heard. Okay, and then so there's not been a hearing on that yet, right?
No. But that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and